All right, it is about that time. You ready to go, Katie? Good, okay, great. Corey, you ready to start?
Yep.
Okay, then I will count us down and we'll launch the event. We will start the event in 5, 4, 3, don't forget the pause, Corey, 2,
Yep.
1.
All right. Hello and welcome. We are pleased to bring you the Service Animals Accessing Public Places training. And this is brought to you in celebration of the National Disability Employment Awareness Month. We have done this in collaboration with Michigan Department of Civil Rights, the State of Americans with Disabilities Act Compliance Division. And now I will turn you over to our colleague, Julie Holmes.
Thank you, Corey. Hi, I'm Julie Holmes, and before we get started today, we would like to acknowledge the behind-the-scenes supports provided to us by our colleague, Tyler Gross. Tyler is instrumental in providing technical supports and troubleshooting as needed throughout this presentation. With that being said, we ask for your patience should anything go astray with our technology today. I would also like to go over a few housekeeping items. This is an interactive webinar, so you may ask and answer questions throughout the event in the Q&A section on your Zoom interface. Time is also reserved at the end of the webinar for you to ask any questions that were not answered. Closed captioning is available by selecting the CC closed caption button on your right lower hand corner of the screen, and then click on Show Subtitle. For any technical assistance, you may contact Zoom at the Zoom Help Center. As mentioned today, the presentation is designed to be interactive. Please use the chat feature to share your thoughts or to ask any questions. Now I would like to turn it over to my colleague, Lisa Stanley, as she will introduce today's presenters.
Good afternoon, Good afternoon, everyone. Hi and welcome. I am Lisa Stanley. I'm a business relations consultant with Michigan Rehabilitation Services. Today, we would like to welcome two of our presenters. We have the privilege of being joined by two state of Michigan experts in the topic of service animals and how they relate to the Americans with Disabilities Act and accessing public spaces. Please join me in welcoming Tyra Khan, Interim Director, ADA Compliance Director, with us right now. Tyra has been with the state of Michigan Department of Civil Rights since 2002, and she's a member of the State Bar of Michigan since 2003. She began her career with MDCR as an investigator for the Enforcement Division and has worked in many offices throughout the state. She later moved into a staff attorney position, providing legal guidance and technical assistance to the enforcement teams from initial contact with a complaint throughout the investigation process to the authorization of a charge or other dispositions of a complaint. Since August of 2021, Tyra has been the interim ADA compliance director for the state of Michigan, working under the umbrella of MDCR. She has extensive experience in the civil rights laws with emphasis on disability laws and issues, fair housing rights, and accessible design and construction elements. Tyra has completed several certification programs under the National Fair Housing Training Academy, as well as the Americans with Disabilities Act Coordinator Training Program. We welcome you, Tyra. I would also like to take a moment and introduce Kelly Frake. Kelly works within the Michigan Department of Civil Rights, MDCR, State ADA Compliance Division as a compliance analyst under the interim State ADA Coordinator, Tyra Khan. Kelly holds a bachelor's degree from Michigan State University, go green, and obtained her ADA coordinator certification in 2020 through the Great Plains ADA Center's ADA Coordinator Training Certification Program, also referred to as ACTCP. Kelly has worked in MDCR's ADA Compliance Division since 2017 and oversees the state's Voluntary Service Animal Identification Program. We welcome you, Kelly. We appreciate the collaboration that allows us to explore such an important topic. Now, I would like to take this opportunity to turn this presentation over to our guest, Interim ADA Compliance Director, Ms. Tyra Khan.
Thank you, Lisa, Tyler, and everyone at MRS for allowing us to present to you today. And thank you for the very warm welcome. We're very excited and looking forward to presenting information to you and then also opening up for questions and answer period. So today what we're going to talk about is the Americans with Disabilities Act, specifically Titles 2 and 3. And we'll talk about what that means and how it pertains to rights and obligations for service animals. Next slide, please. So the agenda today, we're going to again talk about what laws apply when we talk about having service assistance animals. There are state and federal laws that lay out the obligations and rights of individuals, as well as state and local governments and businesses that are open to the public. We're going to talk about what are, or if there are, certification or registration requirements to have a service animal, and the different types of assistance animals that people with disabilities use on a daily basis. Kelly is going to talk you through what are the training and behavioral components of what make an animal a service animal, and provide information to what we call covered entities. And here, when we're talking about covered entities under Title II, it's any state or local government or department contained therein. And then Title III are businesses that are open to the public, and we'll expand on that a little bit more. Kelly is also going to talk about what are the exclusions or exemptions for service or assistance animals. And then we'll also provide and talk about a little bit of other laws that touch and concern assistance animals, and resources that you can look to for guidance after this presentation. Next slide, please. So this is our little legal disclaimer that we just want to make sure that everyone understands that this presentation is for informational and educational purposes only. It's not intended to be specific legal advice. So if you do require legal advice, we advise you to speak with someone in your department who handles, providing specific legal advice to your particular situation. Dissemination or sharing of the contents of this presentation is prohibited unless explicit permission is granted by the State of Michigan ADA Compliance Division. Next slide. So where do the laws come from, and where do the guidance come from to assist people with knowing what the obligations are to have assistance animals? So in 1990, a federal law was passed, and we're all probably most people are familiar with the Americans with Disabilities Act. It was passed. It's a civil rights law that's very broad and covers many aspects of public life when it talks about the rights of persons with disabilities. The law was amended by Congress in 2008 to expand and open up a little bit the definition or requirements of how to show that you're a person with a disability. Because as it was originally enacted, case law came after that, which was very restrictive, and it kind of kicked a lot of people's cases out, discrimination lawsuits for disability, because the courts were saying that you're not disabled enough or you're too disabled, and they were putting a lot of restrictions on what the definition of a disability was. So in order to restore the intent of the law, it was amended in 2008 to kind of widen those definitions and protections. Again, as I said, the ADA is a civil rights law. It's not a check off the box law where it says, here's what you can do, here's what you can't do. Kelly says it's a thinking person's law, which means that you really have to read the law and apply it to fact-specific case-by-case situations. Because if you have to provide someone with an accommodation, it's really specific to that person, right? There's no one size fits all when it comes to disability law. So today we're going to focus on, again, Title II and Title III. Please note that Title I covers employment and employer responsibilities and accommodations. And under employment, it can include other types of assistance animals other than just trained service animals. But here we're only going to be talking about the requirements and obligations for trained service animals under Title II and III. Next slide, please. So Title II and III, again, public entities and accommodations. So as I said, Title I covers employers' employment. If they have 15 or more employees, they are bound to provide accommodations for people with disabilities. Title II, it applies to state and local governments, any department, agency, special purpose district, or other instrumentality of the state or states or local government, and the National Railroad Passenger Corporation and any other commuter authority. So that means if you work in state or local government, chances are the ADA is going to apply to you. Public accommodations under Title III, as Kelly wrote here, it's in a nutshell. So it really means any private business, not a government-run entity, a private business that's open to the public and affects commerce, and any facility that serves clients or customers. So this includes a lot of different things, including commercial facilities. It includes restaurants, doctor's offices, grocery stores, gas stations, movie theaters, the list goes on and on. Next slide, please. So some of the other laws to be aware of, we're not going to go into great detail about these, but just to kind of be aware of, these are things that really do surround the service animal issue. Public Act 144 of 2015 really laid out what are the consequences for someone who harasses, impedes, or assaults a service animal. And it provides that it's a misdemeanor, punishable of up to 90 days in jail or up to a $500 fine, or both, if someone does any of those things to a service animal. Excuse me. The next one is Public Act 145 of the same year. As you can see, these were all passed in the same year. It talks about the fact that service animals are, although they can't be charged fees, state or federal fees, or any kind of registration fees, they're not exempt from vaccinations or local rules when it comes to animal control, health, or health or safety, things like that. Public Act 146, that laid out the responsibilities of the Department of Civil Rights to oversee this voluntary service animal program, which allows for people who meet the requirements to get an ID and a patch for their service animal. And I know Kelly's going to talk about this more in detail. It's an emphasis on voluntary, because under the law, you do not need to have a patch or ID or a vest or a certification or registration in order for your animal to be a service animal. And Kelly's going to talk about how you make an animal a service animal, or what makes an animal. Okay, and then the final one is Public Act 147, which again, it says that it's a misdemeanor to hold your animal out as a service animal if it's really not, and it's considered to be fraud. And again, a misdemeanor is that punishable of up to 90 days in jail and up to a $500 fine, or both. Next slide. So now I'm going to turn it over to Kelly to get into the kind of meat and potatoes of the program.
Thank you, Tyra. This is Kelly Frake. And as was mentioned in my bio and also by Tyra, I oversee the Michigan Department of Civil Rights Voluntary Service Animal Identification Program. So over the past few years, I've had a lot of conversations with businesses and applicants and people with disabilities, looking for information and clarification on service animal law, especially the ADA. So I like to start out by talking about one of the biggest misconceptions that we see out there, which is certification and registration. So I'll just start off by walking you through the voluntary program that we have, and then I'll go into more details about the myths surrounding certification and registration. So MDCR, we do offer a free service animal patch and ID card to any qualifying applicants. All of the eligibility requirements are listed on the website. It's www.michigan.gov/service animals. And on that website, we do have an application. It has 4 parts. The first part is just informational. It's about the applicant and the service animal. The second part is a statement from a licensed healthcare or rehabilitation professional. And part 3 is an applicant affidavit that they have to sign and notarize. And part 4 is the applicant photograph, which is what we use for the ID card. Something I want to highlight, which you can also find on that service animal website, is our new FAQ on service animals in Michigan. A lot of that information is taken directly from the Department of Justice FAQ on service animals. So it's a really, really great resource. So I highly encourage that you print that off, check it out, and just use it as a reference guide going forward. So here's just a picture of what the patch and the ID card looks like if someone were to be approved for identification through the program. The only difference would be that the ID card doesn't have the watermark behind it. Now, the reason I start with certification and registration and talk about that is because this is where I find a lot of businesses and a lot of staff will get themselves into trouble, because one of the first things that they ask for, if they're not sure if someone's animal is a real quote unquote service animal, is, well, show me your ID card, or where's its vest, or can you give me some documentation? And when it comes to service animal certification or registration, this cannot be required under the ADA. Legally speaking, it just doesn't exist. And what I mean by that is the DOJ and other law enforcement agencies don't recognize any form of certification or training program or special registration card as proof that someone's animal is a legal service animal. So you cannot request or require things like certification, registration, identification as a barrier to entry or service. Couple reasons for this: just having these documents doesn't bestow any rights on the individual. There's no special card that can turn an animal into a service animal. We'll talk about the requirements for training for service animals later. But just for now, it's important to understand that there's no special card, no special doctor's note, no special patch that's going to turn a dog into a service animal on its own. And most importantly, documentation doesn't guarantee proper training. And training is the most important part when it comes to a service animal, because under the ADA, service animals are legally defined and protected by their disability task training and their behavior in places of public accommodation. And we will go into each of those pieces, the training requirement and the behavioral requirements, later on throughout the presentation. But I just want to drive that home to begin with. Anything you've heard about certification and registration when it comes to a service animal, it doesn't matter. I like to call it, it's just a fancy name tag, really. So what's more important is the training and the behavior of the animal. Something else I'll mention that Tyra briefly touched on is service animals are not required to wear a special vest, harness, color, or anything else indicating or identifying them as a service animal. Again, it's more important that the animal has been trained and is behaving properly than it is what that animal may be wearing. So let's get into the definition of service animals. Service animals are a dog or miniature horse, individually trained in work or a task that mitigates their handler's disability. The animal's work or task must be directly related to the handler's disability. So for example, you could have a dog that you've trained to pick up items, open doors for you, open up your cupboards, bring you your phone. But unless you have a disability, like a mobility disability that keeps you from doing those things or substantially limits you in doing those things, then you don't really have a service animal because it's not performing those tasks related to your mitigating a disability. It's just a well-trained pet at that point. There are no breed restrictions for service dogs, and service animals are, above all, disability aids and not pets. Now, what I like to mention here is, yes, they are disability aids. They're there to perform tasks that will mitigate their handler's disability. That's why they're allowed to go into places like grocery stores, hotels, etc. But they're also living creatures. It would be the same as someone going into a hotel with a personal aide or a personal nurse, someone to help them. Yes, they're there to do a job and perform a specific duty, but they're also living. They may need to take a break, get a drink, eat food, go to sleep. So I like to mention that in terms of when we're talking about service animals, because there may be times where they're outside and they may be on break. So they may be at a park running around like a regular dog, enjoying their time because it's their time off. So just because you see someone with a service animal and the service animal's having fun or eating or drinking water, it doesn't mean that animal's not, that it hasn't been properly trained or that it's not legitimate. It may just be that the animal is on break. Something specific I'll mention about miniature horses. If you actually look up the definition of service animal in the ADA, it will not mention miniature horses in the specific definition. It will specify dogs. The reason being is that miniature horses were added later in that 2008 amendment as an alternative to dogs. So while you won't find it in the federal definition of service animal, it'll be located a little bit further down and it'll be its own carved out exception for miniature horses. They also added 4 assessment factors to help determine whether or not a miniature horse can be accommodated by a facility. The first is the type, size, and weight of miniature horses. In general, mini horses will be about 34 inches in height when measured to the shoulder. They'll generally weigh between 150 to 250 pounds, but that's just a general range. They can be smaller than that. They can be larger than that, which is why this assessment factor was put in place. 2, 3, and 4, while it's specific to mini horses and doing an assessment for miniature horses, I would say in some ways, these could also be applied to service dogs, and we'll talk about that more later on. So whether the handler has sufficient control of the miniature horse, that also applies to dogs. Whether the miniature horse is housebroken, that obviously applies to service dogs as well. And then whether the miniature horse's presence in a specific facility compromises legitimate safety requirements that are necessary for safe operation. So those would be the assessment factors used if someone came into a business with a miniature horse as their service animal. So that brings us to our first scenario. And for this, I'll read it off. And if you can go ahead and just put your thoughts in the chat, you can send them straight to me if you like, or post them to everyone in the chat. Scenario 1 says that Juan owns a small monkey and has a mobility disability. He has paid a lot of money for a professional animal trainer to teach his monkey how to open cabinets, retrieve items, and turn on lights in order to mitigate his disability. The monkey is legal for Juan to own, is well behaved, and is well kept. Under Title 2 and 3 of the ADA, which is what we're talking about today, does Juan's trained monkey meet the definition of a service animal? Why or why not? So take a look at that scenario. Let me know in the chat if you got any ideas. Feel free to take a guess. Okay, here they come. So someone says no, because it's not a dog or mini horse. Someone says yes, the jobs are to help mitigate his disability. Okay, so the answer to this one, when it comes to a service animal and what is qualified under the ADA, this would not be considered a service animal under the ADA because the only recognized species are dogs and miniature horses. You will never find a service cat. You will never find a service iguana. You will never find a service possum, which someone has called about before for me. So yes, this animal could have been professionally trained to perform all these tasks. It could be very helpful to this individual. They could have a qualifying disability, but because that animal is not a dog or miniature horse, it's not an approved species, it is not recognized under the ADA as a service animal, which means that a place of public accommodation like a grocery store, hospital, etc., would not have to allow that animal, regardless of training in this instance. Yeah, someone mentioned the possum. Yeah, that was an interesting phone call in our office. We've also had parrots and a bunch of other different kinds of critters. So now that we've talked about what a service animal is and how it's defined, let's talk about other types of common assistance animals. Assistance animal is the umbrella term that we use to sort of describe these types of working animals, specifically animals related to healthcare usually. So two other major types besides a service animal are emotional support animals and therapy animals. Emotional support animals provide emotional support to mitigate their handler's disability. Typically, it's provided through the presence of the animal or just the therapeutic benefits of interacting with that animal, very much like pet and owner interactions that can have a very therapeutic benefit on the person's health and on their disability. There are no disability-related task training requirements for emotional support animals. However, emotional support animals are only covered under the Fair Housing Act, and potentially they can be a Title I employment accommodation, but that would need to be evaluated as any other employment accommodation would be evaluated for effectiveness, reasonableness, how it helps the person perform the essential functions of their job, so on and so forth. But really, most often they are covered as Fair Housing Act housing accommodations. So this would be in like an apartment complex that doesn't allow pets. They could be asked to modify that no pet policy to allow an emotional support animal. However, again, you're not going to see that animal going into grocery stores, hotels, hospitals, ADA covered locations. It would only be as a housing accommodation. Therapy animals are very different. Therapy animals provide comfort or support to many people regardless of disability. These are the animals that you see going into hospitals, working with sick patients. Sometimes they'll go into schools and visit children, providing that stress relief, that mental health support. So for this reason, the behavior requirements are actually dictated by the trainer, so the one who's training this animal to go into these places and be comfortable and well behaved, but then also the client. So if it's a hospital inviting in a therapy animal, they might ask that you go through a specific training program. They might only take therapy animals from a certain program. They might ask that it only be in certain areas of the hospital. That client is going to dictate the behavioral requirements and sort of the rules of working in that facility. And it's because therapy animals have to be invited into places of public accommodations. They're basically a service that's being hired by that place of public accommodation to come in and perform therapy animal services for many people. And again, that's regardless of disability. Any questions on ESAs and therapy animals before I move on? I see one in the chat. Let's see. Can any animal be an emotional support animal, even a rat? That's a really good question. When it comes to emotional support animals and even therapy animals, you'll see there's a little cat picture on this slide, and that cat is wearing an emotional support animal vest. And the reason behind that is yes, assistance animals, emotional support animals can cover other types of species other than dogs and miniature horses. So it could be a rat, could be a cat. I will try not to rhyme the last one. Could be one of the strangest ones I had, but it was a good reason, was tarantulas. And the brief story behind that was it was a mother and her son, and the son was on the autism spectrum. And he just gained a lot of comfort from being able to go into his room and just watch his pet tarantulas. And it really helped calm him down. It helped when he had episodes where he was sort of out of control in the home. And it was very helpful for him to have those tarantulas in the house where he could just go and sit for a quiet time and watch them. And it would help him calm down. Now, obviously, those tarantulas aren't task trained. It's just the presence of those animals that's providing him a therapeutic benefit. But that would be an example of an emotional support animal. Tyra, I don't know, did you want to speak to unique animals under Fair Housing Act?
Yes, this is Tyra speaking. I will. Yep, I'm glad that you mentioned that because it was just in my mind. So HUD is the federal entity that handles fair housing. So they're very similar to the Michigan Department of Civil Rights. It's our federal counterpart. And we do have a work share agreement with them so we can investigate complaints under state and federal fair housing law. So they put out some new guidance last year because it's so confusing, right? There's emotional support animals, assistant. There's so many different verbiage that people use. And so Kelly is really focusing on the trained service animals. But when she talks about unique animals and things that are other than service animals, as she said, it only applies to housing. So we've had many different types of animals, guinea pigs, goats, as Kelly said, a tarantula, chickens, pigs, anything that is unique or not a domesticated animal. So cat, dog, bird, fish. The HUD says that the person asking for a unique or individualized animal like that has to be able to show a nexus or connection between the disability and why they need that animal. Why do they need the specific animal of a tarantula? So, and that really comes down to having some type of medical care professional provider, whether it's a therapist, a primary care physician, a social worker who's dealing with the client and knows intimately why they need that animal. Someone in a medical professional role has to explain why they need that particular animal and why a cat or dog or a fish wouldn't provide the same therapeutic benefit. It's not always easy to show. And sometimes people get hung up on those things, right? They're not able to have a medical care provider explain why they need that. But that's what the law says. And because there has been such pushback from the housing corporate side of it with people bringing these kind of animals. So there is a little bit of difference in what you have to be able to explain or prove that you need.
Thanks, Tyra. This is Kelly. It looks like we had another question come in just about housing. So maybe we could quickly address this and then move on because I don't want to spend too much time on housing. But the question is, for an emotional support animal or dog in a housing complex with a no pet rule, can the individual, or I'm sorry, can I have clarification on this question? Is it a complex that allows pets or does not allow pets? But the question is, does not allow pets. Can the individual be required to provide the landlord medical documentation?
This is Tyra speaking. Yep. And that's exactly how it happens, right? So most of these places nowadays have a no pet policy, which they can have that. They can absolutely have a no pet policy, but they have to make exceptions under the state and federal fair housing law for service and assistance animals. And they have to allow for those animals, and they certainly can ask for documentation to show. Now, I don't know how deep dive Kelly goes into, we're not talking about service animals, right? So for a service animal, if your disability is obvious, right, and you have a service animal, there are limitations to what the housing provider can ask, because if they can visibly see that you're a person with a disability because of a mobility issue or missing limbs, or you're using the assistance of a cane or a guide dog, there's limitations on what they can ask. But we're strictly talking about not service animals, right? Emotional support animals. So those are what we call hidden disabilities. We don't always know and can't always tell by looking at someone that they're a person with a disability. So the housing provider has a right to ask for verification that the person meets the definition of a disability under the law, but they don't have the right to know their diagnosis or medical history. And two, that they have a need for that specific animal. And so long story short, yes, they can ask for verification.
Thanks, Tyra. This is Kelly. And the reason we bring up emotional support animals, therapy animals, assistance animals in general, which can include kind of a gray area of animals that may perform tasks, but maybe aren't well behaved enough to go into places of public accommodation, like grocery stores, hotels, hospitals, etc., is just to sort of explain, because a lot of businesses that I've spoken to in the past, they get frustrated because they see a lot of people coming in with animals that are not well behaved, or maybe that are a little bit questionable in terms of their training, and they get frustrated. And it's easy to see people bringing these animals in as, well, they're just trying to take advantage, or they're doing something with a malicious intent. And a lot of times when I talk to people, it's not from a place of it's not from a malicious place, or that they're trying to get away with something. It's more from a place of confusion, because you could have someone who has, let's say, an emotional support animal cat, and it's perfectly legal for them to have this cat in their apartment, and they've gone through all the appropriate steps. The issue comes when they then try and take that emotional support animal from their apartment into an ADA covered location, like a grocery store, like a theater, like a hospital, and that animal is not covered in that location. So it is confusing for some people that are not familiar with the law, which is why I like to bring that up. Because I think a lot of times when businesses especially are working with customers, you can get a lot further with people if you approach things from a standpoint of being educational and providing information as opposed to making accusations. So let's go back to that first scenario, and I'm just going to ask a slightly different question now that we've covered emotional support animals, therapy animals, and other types of assistance animals. So it's the same scenario. Juan owns a small monkey. He has a mobility disability. This animal, this monkey, is trained to open cabinets, retrieve items, turn on lights in order to mitigate his disability. The monkey is legal for Juan to own, it's well behaved, and it's very well kept. So under the Fair Housing Act, which is what we just discussed, could Juan's trained monkey be considered a housing accommodation? Why or why not? And don't feel free to take a guess. We can always talk about it. I won't read anyone's name aloud, I promise. This is just to see how well we're following, or if we have to go over something again. I just want to make sure everyone leaves here today not being confused. Okay, looks like I got some answers coming in. Yes, with documentation. I think so, because it's trained and can be emotional support animal. Yes, yes, but it stays in the house, not in a grocery store. Yes, yes, with the correct documentation. Yes, so it looks like we're all on the right track, which is really good to see. So again, Fair Housing Act can cover a wider range of assistance animals and species. So it could cover a trained monkey, whereas you wouldn't be able to take that monkey into an ADA covered location, but it could be a housing accommodation. All right, so let's move on to talking about training, specifically service animals that are still in training. People with disabilities do have the right to train their own service animal. Something I'll say about this is that the behavioral expectations and the task training requirements, they remain the same regardless of the training method. So you could get a quote unquote professionally trained service animal from a reputable organization, spend upwards of $10,000 to $20,000 having this animal trained for multiple years and then provided to you, or you could self-train, and the threshold and the expectations for that animal will remain the same regardless of how it was trained. What I mean by that is professionally trained service animals aren't held to a higher standard than self-trained service animals. Service animals are not covered by the ADA or in Michigan until their disability-related task training is complete. I bring this up because some other states will have service animal and training laws where they will allow certain organizations, or in certain instances, they will allow people to conduct service animal training at specific locations. That's not the case in Michigan. In Michigan, we follow the ADA to the letter. We say service animals in training are not required to be admitted until they've completed their training. Now, what I tell businesses is that doesn't mean that you can't necessarily allow service animals in training, and it can be very beneficial to partner with trainers or people in your area to make sure that those animals are getting the proper, we call it public access training and exposure to different locations. But the only thing is that they are not required to be admitted until they've completed that training. So those two service animal questions are what we use when a covered entity like a state of Michigan department or a movie theater or a court is uncertain of whether or not an animal is a trained service animal. These are the two questions they can ask. The first is this a service animal required because of your disability? And that is there to help, one, just to determine that it's a service animal, or at least the person's claiming it's a service animal and not like an emotional support animal, which would not be allowed. This can also be helpful for instances that I've seen come up before that are like, well, it's my husband's service animal. Okay, but unless you have a disability that the animal has been trained to assist with, it's not acting as your service animal in that instance, and it's not really for you, it's for somebody else because you don't have a disability. Number two, what work or task has the animal been individually trained to perform? And this is the biggest question that will help you separate trained service animal from emotional support or a non-service animal. When we ask this question, if someone just responds by saying, well, the animal calms me down, that's not really a task. That's an effect that the animal is having on you. So you may have to ask a clarifying question about, okay, what task does the animal perform that calms you down? And if it's just the presence of the animal, if the person just is very adamant that they just have to have the animal with them, that's emotional support, because that animal has not been specifically trained to perform a specific action or task or work that will mitigate that person's disability. It's just the presence of the animal providing that therapeutic benefit. What we're looking for in terms of work or task would be something like, say, same thing, well, the animal calms me down. But they could expand on that and say, well, my animal is trained to lead me to a safe location. For example, a lot of PTSD service animals will actually be trained in a task called excuse to leave. And the version that I've seen in the past is the individual will, if they're in a situation where they're starting to feel overwhelmed or they're starting to have symptoms, maybe about to have some sort of anxiety or other attack where they just need to get out of that situation. In order to do that in a way where they won't have to draw attention or embarrass themselves or basically draw attention to the fact that they have to leave right now or they're going to have an attack, they can do something. And what I've seen in the past is the version I saw was they put like an upside down V, very subtle sign just on their hip. And then the animal was trained to put both paws up on the hip. And then the handler, the person with PTSD, would say to the people he was speaking with, oh, I'm sorry, my service animal has to go outside. And that would give him an excuse to leave the situation in a more private matter. So that's an example of a specific task that that animal has been trained to perform. It's not just the presence of that animal that's making this person feel better. They're actually trained to recognize specific cues, whether it's the person's disability-related cues, physical cues, or an actual hand vocal command. So those are the two questions you can ask. You cannot, as a place of public accommodation, ask about a person's disability, require medical or training documentation. Again, people can self-train their animal. You can ask that the service animal demonstrate its work or task. A lot of times, certain tasks will be triggered by specific events or specific physiological responses. Diabetic alert dogs, for example, are trained to detect when their handlers' sugar levels are out of balance. And that's not something that's easy to replicate unless it's actually happening. And then finally, you cannot ask the two questions if the person's disability and the animal's tasks are apparent. The reason being is because at that point, you don't need to. It's apparent. You can see or perceive that this person has a disability, and you can also see that this animal is performing specific tasks related to that disability. So there's no reason to ask the two questions. You already have the answers. I do want to go over a few tasks, some of which you may be familiar with, others might be new to you. Assisting individuals who are blind or have low vision with navigation. I think many of us are familiar with guide dogs. Those are kind of the most popular or most known form of service animals. There's also animals that alert their handlers who are deaf or hard of hearing to sounds. This could either be done through barking, but it's not typically the sound that's alerting the person. It's just the visual cue of the animal opening and closing its mouth. It can also bring things to the handler that are making noise, such as the telephone, which gets into this third bullet point of retrieving items such as medicine or their phone if it's ringing, or medicine if it's time for them to take it. They can alert an individual to oncoming seizures, so that way they can get to a safe location, get help if they need to, if they know a seizure is going to occur in just a few minutes. They can prevent or interrupt impulsive or destructive behaviors. A lot of times this will come up with maybe mental health disorders or individuals on the autism spectrum who may have repetitive behaviors that they do, or self-harming behaviors that they do. Maybe they're hitting their heads over and over. And what the service animal is trained to do is physically put themselves between, let's say the person's hitting their head, put themselves between the person's hand and their body, so that way they stop that destructive behavior, the self-harming behavior, and then they're also trained to redirect the person's attention to the service animal so they don't continue doing whatever that negative behavior was. Again, this is not, I pet my dog and I feel better. The animal is trained to notice cues of the person's disability and then perform an interrupting behavior and redirect that person's attention to the animal. It's a defined, trained task with a defined trigger. And then service animals can also provide physical support and assistance. So sometimes people will use their service animals as a living crutch. So the animals can help people with mobility disabilities get up out of chairs, climb stairs, and walk alongside them to provide stabilization. They can perform physical support duties as well. Okay, second scenario. Jade is blind and uses a trained guide dog to navigate her surroundings. She enters a grocery store with her guide dog, who is not wearing a vest. However, staff can clearly see that Jade is blind and that her dog is helping her navigate around produce displays. The dog is well-behaved, focused, and under control. Should staff ask Jade the two questions to determine if the animal is a trained service animal, why or why not? Let me know what you guys think. Okay, someone's saying, no, you don't have to ask, it's obvious. Someone says no, because it's apparent that she has a disability. No, because you're able to see the task the service dog is completing. A few people saying, no, you can see the task. Good, so it looks like we're all on the right track. I'm seeing mostly no's, if not all no's. So that is correct. In this instance, you can, it's ostensible. It's clear that the person has a disability. Jade is blind. And it's also clear what tasks the animal's performing. They're helping her navigate around these produce displays. In these instances, you don't have to ask the 2 questions, you already have the answers. All right, scenario 3, a little bit different. Lee has a prosthetic leg. He enters an office building as a customer and is accompanied by a pit bull and a PTSD service animal vest. The dog is well behaved, but does not appear to be performing any tasks. When asked the 2 questions by front desk staff, Lee claims that he is a veteran and that the dog provides emotional support. Are staff required to admit this animal? Why or why not? When you're thinking about this, think back to our conversations around emotional support animals and where they're covered. Okay, some people are saying no, the animal is not doing any specific task. It has a calming effect. Someone asked another question, what support does the dog perform? Someone saying yes, the task is providing the emotional support. Someone else asking the question, what is the actual task or work being done? So I like to see this because it's showing me that you guys are starting to think, you're starting to use these different concepts and think maybe a little bit further about this situation and maybe some additional details that you might want to ask for. So in this instance, if you've asked the person the 2 questions and they just respond by saying that they're a veteran and the dog provides emotional support, 1, they haven't really answered, yes, they're a person with a disability and the dog is their service animal. So they haven't really answered the first question. And then 2, saying that the dog provides emotional support. Again, emotional support animals are not covered under the ADA. So you would not have to allow that animal at that point. Now, if the person were to go on and say, no, the animal does, and then explain the specific task, yeah, maybe, but again, they still haven't answered that first question. So something I like to bring up with this scenario is that we covered the 2 legal questions that you can ask on this slide. If someone refuses to answer these 2 questions, or if they're not providing sufficient information that would allow you to know what the work or task of the animal was, if they just kept saying, hey, they're for emotional support, I don't want to answer any more of your questions, they're not providing enough information there. And for individuals who don't answer these 2 questions or don't provide sufficient information to these 2 questions to separate their animal from being an emotional support animal or just a regular pet, they have to specify the task, then you don't have to allow that individual. If someone doesn't answer the 2 questions and you've asked them the 2 questions, that's fine, but you don't have to allow access to that animal because they're not giving you enough information as a business or a place of public accommodation to not designate, to have an understanding that this animal is a trained service animal and not just a regular pet. Someone asking if they can have a copy of the PowerPoint, I'm absolutely fine with that. The only thing I will say is please don't share the PowerPoint with anyone else. A lot of things we're going over today, especially in the slides, if they're taken out of context, I just don't want people to interpret it the wrong way without the context of the presentation, but you're more than welcome to have a copy of the PowerPoint slides. I'm okay with that. Okay, so let's talk about behavioral requirements when it comes to service animals. Service animals have to undergo behavioral training. And like I mentioned before, oftentimes this is called public access training in the professional service animal training world. Specifically under the ADA, there are 2 requirements. The animal has to be housebroken at all times in places of public accommodation, and it has to be kept under the handler's control in places of public accommodation. If an animal does have an accident or it's not housebroken, it's actually the handler's responsibility to clean up after the animal. That really shouldn't happen, but in some instances with new service animals, accidents happen. The animal can be kept under the handler's control at all times. I want to define a little bit more what under control means, because this, of course, includes the major things like aggression, uncontrollable barking, things like that. But it can also include things as simple as if you have a retractable leash and you have a service animal, your service animal shouldn't be 30 feet away from you, sniffing around on the ground, being distracted. That's not under the handler's control. They should be right there with their handler, working for them the entire time they're in that place of public accommodation, not wandering around, not going up to other people. That would not be under the handler's control. In addition, a leash, harness, or other tether is required for service animals working in public, and there are only 2 exceptions to this rule, and they're pretty rare. The first is the person's disability doesn't allow them to physically hold a leash. So they might have a mobility disability, or they might have an amputation where they can't physically hold a leash. Also, the presence of a leash would interfere with the animal's work or task. Again, this is very rare, but this could be like for an individual who might have PTSD and their animal is trained to go into a room ahead of them and basically do a sweep to look for any possible triggers. And then they come out and they give their handler basically an all clear signal. And that lets the person know it's safe to enter the room. Also, tasks that are trained for PTSD work specifically is they might go into a room ahead of their handler and turn on a light if the room is dark, and then come back out to the handler if a dark room is going to be a trigger for that person. But again, that's typically short periods of time that animal would be off leash. They go off leash, they do their tasks, they come back, and they're right back on leash. And even in these 2 instances, say you meet 1 or 2 of these exceptions, the animal still has to be under their handler's control by some other means, whether it's hand signals, vocal commands, a clicker. That animal has to be under the handler's control at all times, period, regardless of whether they're on a leash or off. Removal of a service animal. This is very important because this is also where I find a lot of businesses will get themselves into trouble. Animals that fail to meet the behavioral expectations of a trained service animal can be removed at any time. So if they're not housebroken, if they're not under their handler's control, that person doesn't take any action to bring that animal under their control, that animal can be removed. The caveat to that is the handler has to be given the opportunity to receive goods or services without the animal present. And that's where people get themselves into a lot of trouble. They will try and ban both the animal and the handler. You can't do that. What you could do is say to the person, hey, I'm sorry, you need to remove your animal, but you're more than welcome to come back and receive your goods or services at that time. But you can't deny access to the handler based on their animal's behavior. Service animals cannot be denied access due to any of the following: negative assumptions about how an animal might behave. We get this a lot with fear of specific dog breeds. So just because someone's service animal is a pit bull, unless that animal is behaving in a way that's out of control or aggressive or otherwise inappropriate in that place of public accommodation, if it's just being there and doing its job, it's not done anything that would warrant it being denied access. Another reason is fear of animals. Service animals can't be denied for that reason, and allergies. And this is a big one. This is where I always get people who say, well, wait, hold on a second. What if people have severe allergies? So I'll cover this very quickly. The general rule of thumb is if someone with an allergy and someone with a service dog, let's say, have to spend time in the same facility or location, both people need to be accommodated. And if it's a business owner, that business owner has to operate on the information they have. So if someone comes up to them and says, I can't be around that dog, I have a severe allergy, I could go into anaphylaxis, so on and so forth, they can't create a direct threat scenario for that individual with the allergy. They can't put their health at risk, but they also can't deny access to this individual with a disability who needs to have their service animal present to access goods and services. So typically it depends on the situation, but a typical way to accommodate that would be put them in different rooms in the facility, maybe a turn taking if it's a small business or a small location. You could have them take turns coming in and out. There are a number of ways you can accommodate this type of situation, but the point is you have to accommodate. You can't just tell the person with a service animal, no, I'm sorry, you can't come in. Something I'll mention on this before we move on is if you're working with businesses, a lot of times the best practice I will tell them when it comes to removing a service animal, have an incident reporting process, archive evidence, especially if it's because of an animal's misconduct. Because if you have an instance of the same service animal, quote unquote, that has repeated behavioral issues, housebroken issues, they have a lot of accidents, and you've documented this, you can actually ban that specific animal from your location, not do a blanket ban of service animals, but you can ban that specific animal because it has shown a history of being out of control or not being housebroken or whatever the issue is, which is why I always tell businesses have an incident reporting process and include service animal removal in that. All right, scenario 4. I'm going to keep us moving a little bit quicker because I want to make sure we get through the rest of the slides in time. So this question is, Dominic is a person with a disability. He's speaking with staff about their programs and services when his service dog starts pulling on its leash and barking at a customer passing by. Dominic makes no effort to correct the animal's behavior and instead complains about the other customer getting too close. Should the animal be removed? Please explain your reasoning. And while we're waiting for those answers to come in, I see a couple questions about airports. I'm going to hold on to those until we reach the end because I have a slide that's specific to airline and service animal access. So I will hold those questions until we get to that slide. So a couple answers coming through. Yes, disruptive behavior, and Dominic makes no effort to correct the behavior. The animal should always be in control. Maybe it was trained to alert if too close to people with disabilities. I'm glad someone mentioned that. That is oftentimes used by individuals when their animal is behaving like this, barking at passing people or lunging at people, and they say, well, they're trained to let me know when the person's getting too close. The issue with this is that the ADA allows for nonviolent protection work, which is basically the notification of someone getting too close. But if you have a dog that's lunging at people, that's behaving aggressively towards people, that's not going to be allowed as a service animal behavior or task. So in this instance, I would say he really couldn't use that as a defense if that animal is really going after people coming by. So I would agree with many folks who said, yes, this animal should be removed in this instance. Now, should it be banned? If it's a first offense, maybe not. It depends on how aggressively perhaps that animal was behaving in this particular instance. But at the very least, yes, it should be removed from the facility on this particular day. All right, let's talk a little bit about exclusion, and then we'll go into direct threat, and then I can start covering some of the other questions that were coming in. Exclusion of a service animal, pretty rare, but it does happen. If admitting service animals would fundamentally alter the nature of a service or program, or if an undue financial or administrative burden would occur, service animals can be prohibited. So when we talk about fundamental alteration, operating rooms, burn units, these are locations where by the nature of that program, that service, that environment has to be 100% sterile. So you could have the most well-behaved service animal in the world, and just the presence of that animal being in an OR or being in a burn unit would be a health and safety risk to the people there. That would be a fundamental alteration. It's no longer a 100% sterile environment. So it has been decided in previous cases that operating rooms and burn units are specific exemptions where service animals can be excluded. When we're talking about ADA provisions for service animals, those don't overrule legitimate safety requirements. So a couple cases that I'm aware of are Pools, they can't be in the water because, like, say it's a hotel, they would have to drain the pool every time a service animal was in there, because you can't disinfect the water or clean it and the animal will be going around all in the water. It would just be a health and safety risk. So they're not allowed in the pool. They are, however, allowed on the pool deck, just as long as they don't go in the water. In zoos, the idea behind zoos is that certain animals that are the natural prey or predator of dogs will either have an aggressive reaction if they're a predator towards a dog, which can cause a safety concern. Or let's say the animal on display is the prey of dogs, like rabbits, for example, they can actually hurt themselves and sometimes even kill themselves because they're so scared and they're trying to get away from the dog. Even again, if the dog is perfectly well behaved, totally under control, just the presence of that animal being there causes a health and safety concern. So they can be excluded from those parts of the zoo. However, they can't be excluded from the zoo in its entirety. There might be an aquarium part of the zoo that they can go to where there's no health and safety risk. They're more than welcome to go there. They could go to the food court area. So you can't really, under the ADA, it's very rare that you can do blanket bans. You really have to look at the specific locations, the specific safety risks, and then try and allow that person and their service animal the widest access possible without creating a health or safety concern. Let me double check some of these questions coming in. Yeah, so I had a question coming about service animals in the workplace. I know a couple people joined a little bit late. Today we're talking about service animals in public access. I will touch very briefly on employment on a separate slide towards the end, but that's kind of a whole topic unto itself. So I won't be going in too much detail about that. If you do have questions, however, like about airlines or employment, which are some that I've seen come up that don't really relate to the ADA or public access, Tyra and I will have our contact information at the end, and you can always reach out, and I'm happy to discuss that with you as well. Okay, direct threats. This is a really important concept to understand when it comes to service animals. Specifically, covered entities are not required to provide access to individuals with disabilities or service animals that pose a direct threat to the health or safety of others. When we're talking about direct threat, this is a significant risk to the health or safety of others that cannot be eliminated by a modification of policies, practices, or procedures, or by the provision of auxiliary aids and services. Basically, there's nothing that you could do as a business or a state entity that would eliminate this threat. Allegations of safety risk have to be based on actual risks. Perceived threats without any evidence are not going to support exclusion. Again, you can't just say the animal's dangerous because it's a pit bull. What has the animal done that would lead you to believe this is a direct threat to health or safety? When you're looking at direct threat, you have to do an individualized assessment. Like Tyra was talking about in the beginning, the ADA is a fact-specific, case-by-case law. You have to look at the details of each specific scenario. Where did this occur? What was the specific risk factors? And they do provide some assessment factors that you can look at that can help guide you through making a determination. So covered entities have to make an individualized assessment, and they can follow these different criteria, such as the nature, duration, and severity of the risk. So for example, that individual who said they have an allergy to dogs, in that specific facility, how long are these two people going to be in the same room together? How severe is this person claiming their reaction will be if this animal is here? Is it just that they're going to get a runny nose? Is it that their throat's going to close up? What's the severity of the risk? You also have to look at the probability that potential injury will actually occur. So what is the likelihood that there will be a risk to health or safety? And then finally, of course, you have to look at whether providing a modification to policies, practices, or procedures, or providing an additional aid or service will actually mitigate that risk. So here's an example of what is a direct threat versus what is not a direct threat because of the use of modifications or auxiliary aids and services. A direct threat would be a person's service animal shows unprovoked aggression towards other customers and staff by growling and snapping at them if they get too close. There's really nothing reasonable that you can provide there as a modification that's going to excuse this aggressive, threatening behavior on the part of the animal. What would not be a direct threat would be something like this, where a person with a mobility disability has trained her service animal to pick up items with its mouth. In a grocery store, instead of just kicking the animal out, saying you can't have this animal here, they can provide an additional service, or they can provide an auxiliary aid or service is what we call it in the ADA world, where they say, okay, you're welcome to shop here with your service animal. We just will assign you an employee that can assist you with your shopping so that the service animal doesn't have to come into contact and pick up produce and other unpackaged foods with its mouth, because that's not hygienic. But then the person could go about the rest of their shopping on their own with the animal present, and there would not be a direct threat issue there. I'm going to run through these pretty quickly. This is sort of a potpourri of different guidance and information for a lot of different types of covered entities. First and foremost, the handler is responsible for the care and supervision of their service animal. Staff are never going to be required to feed the animal, take care of the animal, take it outside to go to the restroom. They're not going to be in charge of any of that. That's all on the handler. Covered entities cannot assign individuals to specific rooms, tables, etc., due to a person's disability or service animal. We see this a lot with hotels. They'll try and force people with service animals into pet-friendly or pet-only rooms. You cannot do that with someone who has a service animal. They have to have the ability to access any available accommodation that someone without a disability would be able to access. Service animal handlers are also not required to pay additional fees for their service animal. They don't have to pay pet or cleaning fees. Again, this is something that we see come up in hotels. You cannot charge them a pet cleaning fee when they have a service animal. However, handlers can be charged the same fee for damages caused by a service animal as charged to any other customer. So if you do have an animal that you've allowed and someone said, this is my service animal, and that animal causes damage, let's say hotel room, we'll keep going along with that analogy, you follow your same process as you would for any other patron that caused damage to that room. You follow that same procedure. You can charge them the same amounts that you would someone without a service animal. Hotel guests are not allowed to leave their service animals in their room when they leave. Just in general, they shouldn't be leaving their service animal unsupervised. In fact, it's actually a big warning. If you do ever see a service animal without their handler, it can be a sign that that person is having a medical emergency. So they're having a seizure, they might be experiencing anaphylaxis, some other type of disability-related issue. So it's actually very important that if you ever see a service animal without their handler and that animal's coming up to you and seems to be trying to lead you, they may be trying to lead you to their handler to call 911 or get support. Items that are provided for customer use only. This comes up with shopping carts, forks and knives, plates, seating. Those do not have to be provided for service animal use. This was a big thing a few years ago with people wanting to put their service animals in shopping carts. They do not have to allow that. Those items are provided for customer use only, not for your animal. And finally, the ADA doesn't override public health rules that prohibit dogs in swimming pools, which we already talked about, and food prep areas. So what that means is that you could have a service animal in a restaurant as a customer, but they wouldn't be allowed in like the food prep area behind the scenes. That would pose a health and safety issue. All right, service animal fraud, we already covered at the beginning. So again, I'm just going to go over this very quickly just to say that false representation and registration of an unqualified or untrained animal is a misdemeanor in Michigan. Here are the penalties. It could be one of those, it could be all of those. So it can range quite a bit in severity. And then if you do ever suspect service animal fraud, you can report that to local law enforcement for investigation. Let me check my time. I'm a little bit over. I want to make sure we get through the rest of this. So I'm going to skip scenario 5 for now and just say that ADA exemptions I want to bring up are that religious institutions, places of worship are going to be exempt from allowing service animals. This exemption may not apply, however, to homeless shelters, hospitals, or other organizations run by religious institutions when those places are open to the general public. Then they would potentially fall under the ADA. Private clubs can also have certain exemptions. There's more about that in the statute. And federal agencies, they don't fall under the ADA, but they do fall under the Rehabilitation Act of 1973. So whereas we as state entities and businesses fall under ADA, and that's where we get our guidance, the federal agencies have a different set of guidelines. They follow the Rehab Act, although they are quite similar. Okay, so let's get into some of these additional assistance animal laws. I know I saw a lot of questions about airlines in particular. I'll just sort of recap housing to say that just remember, under the ADA, only trained service animals are recognized and only trained service animals are required to be admitted into places like your state government departments, your grocery stores, your hospitals, your movie theaters, etc. When it comes to housing, that's a separate federal law called the Fair Housing Act. They can allow a wider range of assistance animals, including emotional support animals, including some different species. Those can be protected under the Fair Housing Act, but that's a separate law and that's a separate process. The Air Carrier Access Act, the ACAA, is what covers airlines and airports. And up till very, very, very recently, they were actually allowing emotional support animals as well, but they do not anymore. Recently, they did make a determination and said that they will now only allow, again, trained service animals under the Air Carrier Access Act. And I provided some links and additional information if you're curious about the ACAA and service animals and that sort of new ruling that came out. There's some additional resources there. Federal Transit Administration, it's basically exactly the same as the Title II and Title III requirements we just went over. The only difference is that the Department of Transportation never updated their definition of service animal to match the ADA when the ADA did their amendment in 2008. So the Department of Transportation and anything that falls under Federal Transit Administration, just typically public transportation, when they talk about a service animal, they're talking about a dog or other animal, and it's unspecified. So under DOT and in public transportation, this is another area where you could potentially have different species that fall under those protections. And finally, Title I of the ADA covers employment, and that's all types of employment accommodations, including assistance animals and service animals. And they are evaluated the same way as any other workplace accommodation would be evaluated. You'd have to look at it from the standpoint of how is this allowing them to perform the essential functions of their job? Is this reasonable? So on and so forth. But you would evaluate it as a workplace accommodation under Title I. And here's just some other additional informational resources. If you ever just have a question, you want to reach out, you're not sure about something, these are some great places to contact. And then of course, Tyra and myself have information as well. And I know I went a little bit over our time, so I will turn it back over to Lisa, and maybe we can do some additional questions if there are any.
Okay, I don't see any questions coming through. Oh, there's one.
Yep, this is Kelly, I see that. So the question is, what is the requirement to self-train? And again, I noticed a couple of people kind of came in the middle, so we did cover this, but I'll do a quick refresher. So again, the requirements, whether you self-train your service animal or get it professionally trained, quote unquote, or you purchase a service animal from an organization that provides them, the requirements in terms of the ADA are all the same. It's the same baseline regardless. So the main requirements are they have to be task trained in worker tasks that mitigate your disability. And they have to be housebroken at all times in places of public accommodation. And they have to be kept under the handler's control at all times in places of public accommodation. And remember, being under control is not just general obedience training. It's really much more intense than that, because in order to be considered under control, your animal should not be getting distracted, should not be like sniffing for food under tables. If you're at a restaurant, shouldn't be going up to people, shouldn't be 20 feet away from you on a leash, sniffing around, ignoring you. That animal is supposed to be trained to be working for you at all times in places of public accommodation. So it's really a high level of behavioral expectation that's required, whether or not you're self-training or going through an organization. So great question.
Okay. I don't really see any others in the chat. So yeah, I just wanted to thank Tyra and Kelly for the great presentation today. It was very in-depth, and I know I learned some things going through this, but and I also wanted to thank Tyler for the technical contributions that he had that made today's presentation possible. If you have any questions, feel free to reach out to Tyra or Kelly. And thank you all for joining us today.